association with which the negligent club is affiliated will also that association has a duty to play in ensuring full compliance of the provision of Article 5 of the regulations on the status and transfer of players. And this entails monitoring clubs' compliance to ensure that they do not violate the provision of this article. The panel in this case further held in clarity that even if it is the club that is largely responsible for this breach, member association will also be liable for the omission of such negligent club. And it is clear on this standpoint that indeed there is an obligation on Enugu Rangers International Club to update the status of employee in the fact transformation system, and they have failed to do this. Proceeding on the second part of our standpoint, that the failure to upload the status cannot deprive Alina and Intercairo FC their rights, their entitlement to receive training compensation. It is quite clear, pursuant to the case of FK Sarajevo against KDC Western, where the panel held entire that training compensation is to be paid to training clubs that had contributed to the development of such amateur player where he goes on to have a professional contract. Additionally, it has been recognized by the Court of Arbitration for Sport in the case of Sports Club International against Bayern Leverkusen. Citations being provided in our brief of memorial, where the panel held that where a player goes on to transfer from their training club to a club different, that is different from the association, that is affiliated with a different association, such before the end of the calendar year of their 23rd birthday and registered as a professional, then the training clubs will be entitled to receive training compensation. Mr. Arbitrator, in this case, it is clear, pursuant to the agreed statement of fact, particularly paragraph 1, line 4 to 5, and paragraph 2, line 3 to 5, which clearly provides that Aliram and Intercairo had contributed to the training and education of Emperor in this instance. Members of the panel, the Court of Arbitration for Sport held in the case of Rayo Vallecano against Albacete Balompié that the importance to do the needful, and they claim that this is an administrative oversight. However, the position on the third part of our submission that their failure to abide by the provision of Article 5 was to avoid paying training compensation. Members of the panel, it is clear without doubt, pursuant to Article 5 sub 3 of the FIFA Criminal Regulation, that upon the change of status of an amateur to a professional on the electronic player registration system, TMS, which is transfer matching system, will identify the registration of such professional, which may lead to the entitlement of training reward trigger as a subject matter of discussion. Article 2A of the explanatory notes on the FIFA Criminal Regulation has defined training reward trigger as an event related to the registration of a player that may give right to training rewards to the club that have trained such amateur players. The article further went on and listed the examples of training reward trigger as international transfer or domestic transfer with training compensation, and particularly the first registration of a player as a professional. Members of the panel, it should be noted that the processes and steps involved after the registration of a professional player leads to the triggering of training rewards. And where a training reward has been identified by the transfer matching system, of course, the process of inspection period will follow, where FIFA General Secretariat will invite all training clubs and associations to take part in the inspection period in order to determine whether or not some certain clubs are entitled to receive training compensation. However, conclusively on this, the only logical reasoning that we have arose from the failure of the respondent to ensure that they update the status of employee in the fact transfer matching system was to avoid the end goal of the registration system, which in turn will definitely lead to payment of training compensation. It's on this note that the claimant submits as a whole by relying on the provision of Article 17.4 of the FIFA Criminal Regulation, which states that where a member association has failed to declare training rewards trigger to FIFA, then such association shall pay a fine in order to pay restitution to the training club. It's on this note that we are submitting on a whole that the respondents had failed in their obligation to do the needful, and the provisions of the FIFA clearinghouse regulation were couched in a way whereby all processes must be followed. Thank you very much, Mr. Administrator and other members of the panel. My co-counsel will be addressing this panel as regards issue 2.
Distinguished arbitrator and members of the panel, for the purpose of record, J.U. Ekwemuka is my name, and I shall be addressing this panel as regards issue 2, which raises the question of whether or not Enugu Rangers have a duty to pay training compensation to Alaram FC and Intercario FC. Members of the panel, the claimants contend that Enugu Rangers indeed have a duty under the relevant legal and regulatory frameworks to pay training compensation to Alaram FC and Intercario FC. For the purpose of clarity and ease of argument, this issue has been stratified into 2 standpoints. The first, that Alaram FC and Intercario FC are entitled to training compensation for Emperor's development. Members of the panel, training compensation as outlined in the FIFA's regulations on the status and transfers of players works to ensure that clubs responsible for a player's development are compensated when the player is transferred to a new club. By virtue of Article 20 of the regulations on the status and transfer of players, as well as Annex 4 of these same regulations, the right to training compensation is statutorily protected, and it goes further to provide circumstances in which training compensation would be valid. The first being that when a player is registered as a professional for the first time, and the second, that each time a professional is transferred until the end of the calendar year of their 23rd birthday. In the case of Valletta FC versus Apollon Limassol, citations duly provided for in our memorials, the arbitrators held that it can't be submitted that the objective of training compensation is to ensure that training clubs are sufficiently compensated for the cost incurred in training their young players. The obligation to pay training compensation arises regardless of whether the transfer occurs during or at the end of a player's contract. Also, in the case of Sports Club International versus Hellas Verona Football Club SPA, the panel stated that the rationale for the FIFA training compensation system is to ensure that training clubs are adequately rewarded for the cost they have invested in training young players. Members of the panel, training compensation is generally payable for training incurred up to the age of 21, unless it is evident that the player's training period ended earlier. And if the player's training ends before the age of 21, compensation is still due until the calendar year in which the player turns 23. For the amount payable, it is calculated based on years of training completed up to the years when it is determined that the player finished their training. In this instant case, members of the panel and distinguished arbitrator, the player was once an amateur at both Alaram FC and Intercario FC. And given that Emperor is between the ages of 12 and 23, seen as he was born in 2005, as highlighted in paragraph 1, line 1 of the Moot facts, these clubs clearly fall under the category of training clubs as defined by FIFA's regulations, having contributed to Emperor's development, as can be seen in paragraph 1, lines 4 to 5, as well as paragraph 2, line 3 to 4 of the Moot facts. Therefore, distinguished arbitrator and members of the panel, it is clear that both Alaram FC and Intercario FC are entitled to training compensation based on Emperor's development. Proceeding with my second standpoint, that Enugu Rangers International Football Club's failure to pay training compensation to the training club violates the provisions of the regulation on the status and transfer of players. Flowing from our earlier submission on the first standpoint, the claimants contend that Enugu Rangers International Football Club's failure to pay training compensation to the training club constitutes a violation of the regulation of the status and transfer of players. It is important to mention that the regulation on the status and transfer of players is the legal framework governing the transfer of players, and it provides clear guidelines on matters concerning transfer as well as training compensation. Mr. Chief Arbitrator, Article 20 and Annex 4 of the regulation on the status and transfer of player must also be taken into account, as it provides instances when a training compensation would be applicable. In the case of FK Sarajevo versus KVC Westerlo, the panel made explicit reference to the provisions of Article 20 and the provisions of Annex 4. It is evident in paragraph 4 of the Moot compromise that Alaram FC and Intercario FC have not received training compensation, despite the fact that both clubs played a significant role in the development of Emperor, and yet they were deprived of this right. Members of the panel, the claimants are not unaware that should in case a waiver is present, as can be seen in the case of FK Sarajevo versus KVC Westerlo, it can work to prevent training compensation. However, in this instant case, there is no indication following a careful examination of the fact that a waiver is present in this instant case. Therefore, based on the absence of this, as well as other arguments that has been canvassed, we submit on this standpoint that the failure of Enugu Rangers to pay training compensation to the training club violates the provisions of the RSEP. Distinguished arbitrator and members of the panel, it is our submission holistically on issue 2 that Enugu Rangers have a duty to pay training compensation to Intercario FC and Alaram FC, and we pray this court to also. Distinguished arbitrator and members of the panel, for our prayers, we seek to adopt them as contained in our memorials. Thank you very much.
Thank you. We move the floor to the respondent.
Yeah. Can I ask you clearly, and thanks for your great submission. No, just to clarify now. I know I want to ask just where is this instituted?
The Court of Arbitration Court.
Okay.
Thank you, Mr. Arbitrator.
Okay, we move now the floor to the respondent. You can start. Anyone from the panel have another question? Anyone from the panel have another question? Or I delete my question to the end? After finish. So now, you can start. Okay.
As earlier introduced, my name is Amike Precious, counsel for the respondent in today's proceedings. In the next 11 minutes, I will address this panel on the merits of our case on the first and second issues, while my panel in 9 minutes will address this panel on the merits of our case on the third and final issue, while taking our prayers. Chief Arbitrator, honorable members of the tribunal, it is important to begin our submission with a quick remark on the jurisdiction of this case. Chief Arbitrator, while we note that the instructions of the competition has already considered jurisdiction and admissibility, it is important to highlight, according to Article 22D of the FIFA statute, that the FIFA dispute resolution chamber is the one which has the appropriate jurisdiction to entertain this matter. That's also been provided for in Article 50 sub 2 of the 2024 FIFA statute, that it is upon the exhaustion of the internal mechanism of FIFA that the disputes can be brought before the court for arbitration for sports. However, as already adduced, we recognize the fact that this has already been waived in the competition. Thus, we will now proceed to our merits. Esteemed arbitrator, on our first merit, we submit that the claimants are not entitled to training compensation because they have failed to register Emperor, the player. The thrust of our submission is that forced registration as a professional is the element triggering the payment of training compensation. Excellent arbitrator, one key submission is made to advance this argument. That is, the earning or signing of a forced professional contract is merely a preliminary step to professional registration. It is merely a preliminary step to professional registration. A player's contract. In fact, the second part of that same article provides that the relevant member association, which is the Nigerian Football Federation in this case, has the discretion to consider additional contractual materials before deciding on the player's forced registration. Excellent arbitrators. The import of this is clear, that the mere earning or signing of a forced professional contract is not conclusive proof of the professional status of a player. In application of this to the foregoing case, paragraph 3, line 1 of the that Emperor only earned his professional contract after a brilliant 6-month stint as an amateur at the Respondent club Enugu Rangers. It would also interest this panel to note that throughout the whole 6 paragraphs of the Moot problem, the word register was used only once, and it was used in relation to Emperor registration as an amateur with the Respondent club. We submit that this is obvious a deliberate attempt to show that there was no attempt, there was no proper documentation, and there is no form of evidence to suggest or plausible argument or inference that shows that Emperor was registered with the Respondent clubs. Furthermore, excellent arbitrators, this position has been buttressed in a plethora of cases. In Denmark FC Barnet versus FIFA, the CAS panel established that forced registration as a professional is the element trigger for the payment of training compensation. This position and rationale has also been established in the case of FC Bologna versus Barcelona, and also established in the case of Bayer Leverkusen versus FC St. Gallen and FK Sarajevo. All citations duly provided in the Respondent memorial. Honorable members of the tribunal, in spite of this established jurisprudence, there appears to be a misguided notion that the forced signing of a professional contract is the element triggering the payment of training compensation. This flows from the inconsistency in the previous editions of the RSTP. In Calcio Catania versus Montevideo Wanderers, the CAS panel examined the element triggering the payment of training compensation, considering Article 20 of the RSTP, which provided that forced signing of a professional contract is the trigger element for the payment of training compensation. But in this same case, the panel considered Article 2, Paragraph 1, and Article 3, Paragraph 1 of Annex 4 to the same RSTP, and noted that the forced registration as a professional is the element triggering the payment of training compensation. Sadly, we recognize that the panel ruled in this case that it is the signing of a forced professional contract that is the element triggering the payment of training compensation. Excellent arbitrator, it will interest you to note, however, that this statutory inconsistency has now been rectified in the RSTP. Article 20 of the RSTP 2022 edition clearly provides that training compensation is payable to a club upon the player's first registration as a professional. And the same provision is captured in Article 2.1 Annex 4 of the RSTP. Honorable members of the tribunal, the paragraph 3, line 3 of the Moot fact is clear on the fact that the word "end" was used. The word "end" does not suggest that he was registered. It only means that a first professional contract was given to him. Excellent arbitrator, we submit that even if this panel thinks or believes that forced registration as a professional is not the element triggering the payment of training compensation, we note that this case is stated on the basis of the fact that the claimant contained in paragraph 4, lines 2 and 3 of the Moot fact that they have waited for 6 months to see a change reflecting Emperor's status as a professional. However, we would like to draw the attention of this honorable tribunal to the provisions of Article 3.2 Annex 4 of the RSTP, which provides that the deadline for the payment of training compensation is 30 days following the forced registration of the player as a professional. Esteemed tribunal, it is pertinent to note that without this provision or without the player's forced registration as a professional, that this deadline cannot be activated. Thus, the contention of the claimant in this instant case that they have waited 6 months and have not seen any reflection or change in TMS is premature, and it is our suggestion that they should have waited for the forced registration of the professional and the failure of the Respondent club and the member association to update such status before they instituted this claim. Esteemed tribunal, it is our contention that for deadlines and timelines to be activated, For deadlines and timelines to be activated, it must have registered the player as a first professional. This functions as a condition precedent without which the automatic allocation of training compensation cannot emanate from the TMS, as there is no information to trigger the training rewards. Chief Arbitrator, acting members of the tribunal. It is crucial for a fair resolution of the case that Article 4.7 of the FIFA Clearing House Regulation is considered. Article 4.7 of the FIFA Clearing House Regulation specifically provides that the automatic calculation of training compensation is only due to clubs which the player is only due when the player has been registered for the first time as a professional, and this is in accordance with the player's career history as provided in the EPP, that's the electronic player passport. Mr. Arbitrator, this concludes, Chief Arbitrator, this concludes my pleadings on the first issue. In any case that this tribunal holds that the lack of first registration of MPRO as a professional does not preclude the claimant from training compensation, we submit based on our second merit that the claimants are not entitled to training compensation because they have not registered the player MPRO during the training period. The thrust of our argument is this, that for Al-Aram FC and Inter Cairo to be entitled to training compensation, they must have registered the player as an amateur during one of the training periods. Acting Arbitrator, the concept of registration is not one that can be presumed or inferred. It is a process which will be in accordance with strict administrative protocols and must evidence proper documentation. Acting Arbitrator, definition 17 of the RSTP defines the act of registration as one of making a written record containing details of the player. These details can range from the personal data to the club and the member association with which the player is affiliated. In the case at hand, MPRO joined Al-Aram in 2016 and left in 2020. It will also interest this panel to note in the same paragraph 1 that Al-Aram FC was not affiliated at any point in time with the Egyptian Football Association up until 2019, while MPRO left in 2020. It is thus our contention that there is no plausible argument nor cogent evidence to suggest that MPRO could have been registered as an amateur within that 1 year time frame. Also, in the case of Inter Cairo FC, paragraph 2, line 1 of the Moot fact brings a clear fact to us that Emperor only joined the training club when he went for a casual evening stroll. Acting Arbitrator, there was no formal documentation. There is no grain of evidence in the whole of the 6 paragraphs of the Moot problem that suggests that he was ever affiliated with any of the training clubs. It is thus our contention that the registration of an amateur serves a critical purpose for the calculation of training compensation. This position has been further buttressed in a plethora of cases. In Calcio Catania vs Montevideo Wanderers FC, the CAS panel established that the number of months relevant for the computation of training compensation is the number of months or years during which the player was registered with the training club. Also, this has been established in Bologna FC vs FC Barcelona. Importantly, panel, it's most interesting to note that the panel has held in FK Banik and Association Atlético Argentinos that it is a combination of signing and registration of the player as a first professional that triggers the payment of training compensation. Acting Arbitrators, in light of the foregoing submission, it is our candid submission that the claimants are not entitled to training compensation. However, we understand the position of the claimants. While we recognize that they might have at one point in time contributed to the training and education of the player, it is however our contention that had any good Rangers, our clients, had or seen any documentation to the effect that the claimant club partook in any formal training of the player, it would have significantly altered the way we evaluated and interacted with the player. And as such, we submit that if we saw any documentation, we could have maybe not signed the player, or we would have sought for appropriate waivers where such rights exist. Thus, in light of the foregoing submission, we submit that the claimants are not entitled to training compensation as they have violated the express provisions of Article 20 and the clear provisions of Article 2.1 and X4 to the RSTP. This concludes my pleadings on the first 2 issues. Thank you.
Good afternoon, the esteemed panel. As earlier introduced, my name is Paul Adedoye, and I'll be addressing in the next 9 minutes our third and fourth issues before presenting the reliefs that we seek my co-counsel has spent the last 11 minutes demonstrating to this esteemed tribunal that the player has not been registered for the first time as a professional. Hence, there has been no trigger for the training awards. I've also established that the claimants never registered this player, so they have no valid claim to the training compensation. Even if this panel is to go through the route of equity, it's our contention that equity follows the law, and more importantly, if that comes to equity, it must come with clean hands. Why then are we saying that the claimants do not have clean hands? Esteemed panel, Articles 19 BIS subsection 1 of the RSTP provides that all training clubs and academies have the duty to report the presence of all minors at their academy, whether or not the player is registered. Obligation from that of registration. And for the sake of clarity, definition 11 of the RSTP defines the minor as a player that has not reached the age of 18. This provision was enacted in October of 2009, and according to FIFA's commentary, Comment 1, paragraph 2, under Articles 19 BIS, it stated that it was enacted to react to the practice of training clubs enrolling the players without registering them. Paragraph 3 further states that by securing their talent, these clubs will train and develop them, often with a view to registering them at the age of 18, thereby bypassing the need for appropriate approval. This goes against every spirit of transparency. Esteemed panel, if you turn with me to paragraph 1, lines 1 to 2 of the problem, it reveals that Emperor was only 11 years old when he joined Al Aram FC. And paragraph 2, lines 4 of the Moot fact reveals that he was only 16 when he joined Inter Cairo. Esteemed tribunal, this player was only a child. The duty to report all minors who report at the training academies is not only the logical thing or the moral thing to do, it is a legal obligation under Articles 19 BIS subsection 1 of the RSTP. The claimant's failure to report the player demonstrates a deliberate and calculated effort to secure his talent without adhering to FIFA's laws as regards minors. This omission contravenes FIFA's laws to protect the welfare of these young players. It is inexcusable, extreme panel. In the case of Barcelona versus FIFA, Barcelona failed to report the presence of 31 minors at the academy. Their appeal to CAS was dismissed, and it was emphatically stated that the welfare of the minors is to be prioritized over any other thing, esteemed panel. Also, in the case of Atletico Madrid versus FIFA, FIFA's strictness when it comes to reporting minors was fully evaluated and emphasized. Esteemed panel, in the case of US Lebanese versus FIFA, it was stated that the whole purpose of all these laws is to ensure that the young players are catered for not just on-field training, but also a holistic development of their welfare. Esteemed panel, also on still on case laws, Real Madrid versus FIFA, the sole arbitrator stated that Real Madrid actually reported the presence of these minors at the academy. And as we have done in our written memorial, we established that the claimants have failed to discharge this burden of proof. Esteemed panel, in application of all these foregoing judicial and statutory authorities, we submit that the claimants have failed in their duty to report the presence of Emperor at their training academies. Thank you very much. Nowhere in the facts of this case, in the all 6 paragraphs of this case, was it mentioned that either of the claimant clubs actually reported to FIFA or the National Association that an Emperor was in the academy. Still on the doctrine of equity, it's very important to note that equity follows the law. The only time equity allows a deviation from the law is when it's being used as an instrument for fraud. And in our present case, there is no iota of evidence that either of the respondents have acted fraudulently in this matter. In conclusion, esteemed panel, we are not saying that they did not train this player. However, our main duty follows the law and the claimant discharges this burden of proof. Now to our 4th and final submission. Our submission is that the NFF is under no obligation to pay the training compensation. This matter primarily hinges on Article 17.4 of the FIFA Clearinghouse Regulations. Article 17.4 of the FIFA Clearinghouse Regulations creates two circumstances in which a member association will be made liable to pay the training compensation. And the first is when there is a failure to communicate or declare a training rewards figure to FIFA. And the second is when such a failure related to this present matter in the amounts that will be deemed appropriate by this esteemed panel. Thank you very much.
Their mic is off. They are shooting.
Okay. So the Claimant had just 5 minutes to answer about some points the issue. And you can ask them if you want, because this is last point or this is last chance for you. So if you want to ask them any question, you can do so. But everything in 5 minutes you can answer first, and if you want to ask them any question, you can do so.
Thank you very much, Chief Arbitrator and other members of the panel.
But please, it's just in 5 minutes, okay?
For the purpose of our rebuttals, my co-counsel R.B. Abdugani will be addressing this panel. Thank you very much.
Once again, good day, members of the panel. It is clear that the purpose of rebuttals is to clear the misapplication of the law that have been proceeded by the respondent. And in this case, we have 3 grounds of rebuttals where we believed that the respondent has misapplied the law. Before I proceed, the respondent kept on hammering on the fact that registration this, registration that, and equity follows the law. Of course, the first ground of our rebuttal is that we are not contending the fact that the registration of Emperor, we are not contending that Emperor was registered. We are only saying the duty of the law clearly provides that a player must be registered. If such player has earned a professional status, it is clear before we proceed that the law, the framework that regulates Enugu Rangers International Law is the Nigerian Premier League Football, is the Nigerian Football Federation. The framework that provides this as proceeded in Article 13.64 that if a player will be registered, the relevant documents must be provided. And in this instance, relying on the provisions of Article 5 of the FLAM regulation, it provides again that where an amateur player has been registered as a professional or earned a professional status, as seen in this case, the only obligation of the respondent is to update the status of this player. However, they have failed to do this. Pursuant to Article 13.65 of the Nigerian Football League framework, it clearly provides that the period of registration is falls within January 10th till January 30th. And in this case, the first Emperor earned his professional status on January 1st. And pursuant to the regulations on the status and transfer of player, it clearly provides that a player can be registered only twice in a season. The first one being that the player can only be registered in the beginning of the season or middle of the season. And middle of the season in this instance case falls within January. And there is an obligation to update the status of this player, but they fail to do so. If they are now contending that this is an administrative oversight, the position of Article 2 of the RSTP clearly provides that a player can either be an amateur or a professional. Now that they have failed to update the status of Emperor in the FIFA transfer market system, what are we to categorize Emperor as? Are we still going to say Emperor is an amateur or a professional? For the second standpoint, the respondent cited Article 3.1 of Annex 4 of the regulations on the status and transfer of players, which provides that the amateur clubs must show evidence that they registered the particular player before they can be entitled to receive training compensation. However, the respondent has only cited the law in isolation. A careful perusa. Before I proceed, it is important to note that the position of the explanatory notes on the FIFA regulations on the status and transfer of players is only there to clear any ambiguity that may have arise from the position of the regulations itself. And then on this issue of registering him as an amateur before you can claim any compensation, Annex the Article 3.1 of Annex 4 has been given broad interpretation by the explanatory notes on FIFA that if an evidence can be provided that a player received training, the only physical presence of the player is enough to show that this player is registered as the club. This is not the word of the council, but the word of the FIFA claimant, the explanatory notes on FIFA, which shows that you do not need to provide evidence that you trained a player, insofar as the presence of the player can be testified in your contract. And in this instance case, the Moot facts clearly provide that Al-Iram and Zakario FC, both on paragraph 1 and paragraph 2, clearly took part in the training and education of Empro. So we do not need to testify that there is indeed a document that shows the registration of this player. Also, the respondents claim that Al-Iram joined Inter-Cairo as a minor and we failed to update Empro as a minor, and we failed to report to FIFA in as much as a minor. But the position of the law, the position of the facts is clear. This is only logical. When Empro joined Al-Iram FC, he was 11 years old. Of course, we are not unaware of that fact. However, as at the time he joined Al-Iram FC, we were not affiliated with any club. This is just like joining any association. And then when we got affiliated with the Egyptian Football Federation, that was in 2019, 4 years after Emperor joined our club. And then we are entitled to training compensation between 2019 and 2020 that Emperor left our club. So this is only logical that indeed we do not need to report to FIFA because we are not associated with any club. And summarily on this, the position of the Court of Arbitration for Sport is very clear, which provides in the case of Paleta FC against Akuno Limassol that the objective of training compensation system is to ensure that training clubs are adequately rewarded for their efforts on these players. However, the respondents do not want to pay this thing, and this is against the primary purpose of the fact clearance regulation in the first instance. Then to what become the extent of this law?
Yes.
Thank you very much, Mr.
Yes, okay. I think Mr. Muhammad has a question for you.
So, I only have one question to you. Is it for me? Yeah. Okay. They were not asking for evidence that he was playing for Al-Ahram or Inter-Cairo. They were asking for an evidence that the player was registered as a professional player. Do you have evidence that the player is registered as a professional player with them?
May you come again, please, Mr. Arbitrator?
They need what they are asking for.
Yes.
Is a proof that the player is registered as a professional in Rangers. Do you have that proof?
Thank you very much, Mr. Arbitrator. Of course, we do not have a proof that it was registered with them. The facts of the case clearly provides that Empro earned a professional status, and it is in turn an obligation on their part. On Article 5 of the FIFA Clearance Regulation, it clearly provides that where a player was most recently registered as an amateur with a particular club, the interpretation of this is that the most recently registered, the Moot first clearly provides that it was registered, Empro was registered as an amateur with Enugu Rangers International Club, and then they gave him a professional contract. It's only the obligation of the law that, in as much as it's registered, that means he has gotten promotion to by receiving a professional contract, and it is then that they need to update the status. That is our contention, that they failed to update the status. And then the provision of Article 2 of the Regulation of the Status and Transfer of Players clearly provides that a player can either be a professional or an amateur. In this instance, that you're giving him a professional contract, what are we going to categorize employers?
Yes. Okay, I understand. So,
It's okay to...
so we'll move the floor to the respondent, but I want you to answer in 5 minutes, no more. And if you want to ask the question without answer from them, you can do so. Okay.
Thank you very much, Chief Arbitrator.
But we need to answer about everything they arise. Okay?
Duly noted, Chief Arbitrator. We have listened carefully to the submissions of the claimants in this case, and it's thus our submission that we have distilled 5 points of rebuttals. I would address 3 points of rebuttals, while my co-counsel will address 2 points of rebuttal. On the first point of rebuttal, we think it is imperative for this panel to note that there is a distinction between earning a professional contract and forced registration as a professional. Throughout the whole 20 minutes of our presentation, we did not contend whether the player received training and education at the claimant clubs. Our contention is simple: whether Emperor has been registered as a professional at Enugu Rangers. And in addressing this, we submit that the 6-month time frame which they have alluded to as being one of the bane in our case is something which is justified, taking into cognizance the fact that the MPFL framework 2023-2024 is the one regulating the registration of players. And this is pursuant to Article 6 of the FIFA RSTP, which leaves registration of players within the purview of the member association, and pursuant to the NFF power to make laws regulating football and other activities regarding football in Nigeria under the Nigerian Football Association Act. It is our submission that there were other administrative protocols that made us not to register Emperor as a professional, and this is submitted based on one issue. Emperor, in paragraph 1 of the Moot is a foreigner. For a foreigner to be registered as a professional in the Nigerian Premier Football League, the player must have it. They must have a passport, the player must have undergone some immigration processes, and the player must also have undergone a lot of other issues. So there are issues already that exist for Emperor being a foreigner, and as such, it was not possible for us to register the player within the stipulated time frame. Also, our claim, the second point, is that the element triggering the payment of training compensation is the fourth registration of the player as a professional. Throughout the whole 20 minutes of their presentation, the claimant did not appreciate this distinction. They clearly cited Article 20 of the RSTP, relied on Annex 4 of the RSTP. However, they missed the clear wordings of the RSTP, which states fourth registration as a professional, not forced signing, not forced ending of a professional contract. The wordings of the RSTP are clear. The wordings of the FIFA Clearinghouse regulation is also clear in Article 4.7 that states that it is forced registration as a professional that triggers the automatic calculation of training compensation, which is then accruable to the training clubs. It is thus befallen to us why they have simply completed this part throughout the 20 minutes of their presentation. And lastly, as we have already stated for the 6 months, we submit that there is no obligation. They have stated that there is an obligation in law on the training or on Enugu Rangers to register the player. But throughout the whole provisions in the RSTP, not even in the FIFA Clearinghouse regulation, there is no obligation, no provision that states that the clubs have an obligation to register. All that the clubs have is an obligation to bring such to the knowledge of the member association when such registration has been effected. And to the effect that such registration has been effected, there was nothing to communicate with this the relevant member association. It is our submission that if FIFA knew that registration was easy, that they would have put a timeline in place. And because of the cumbersome and bottleneck that comes with registration, FIFA did not do this. Thank you.
Thank you, esteemed panel. The claimants also mentioned that the NFF failed their duty to update status of Emperor. As we've done on our fourth issue, we've stated emphatically that there was no status update to be changed by the NFF, hence the NFF is under no obligation to pay training compensation to the claimant clause. And on our fifth and final rebuttal, it is important to note that the claimants have misconstrued some of the case laws they cited. In Valentina SC versus Apollo Lemasso, paragraph 3 of that case, cited in their memorial, it was stated by the sole arbitrator that Articles 3.1, which states that the trigger, Article 2.1, which states that the trigger is the training compensation, is the registration of the person as a professional, was applied in this case. And also, the sole arbitrator mentioned the case, the provision of Article 3.1, that it is the claimant clubs that have been registered before that are due training compensation. Also, they did take part of the notes of Sports Club International versus Hellas Verona that the reason why training compensation was paid in this case, according to the laws there, as we decided, you must be registered as a professional for the first time. We cannot overemphasize this fact, esteemed panel. The case laws even cited took cognizance of this distinction. Thank you very much.
Thank you. Thank you. Respondent. And just to be very clear, are you saying that a professional contract does not amount to registration?
Esteemed arbitrator, that is the thrust of our submission. A professional contract does not amount to registration as a professional.
Can you throw more light? Are there case laws?
Very well. Mr. Arbitrator, it must be noted in the case of FK Banning versus Association Atlético Argentinos, the CAS panel noted that it is a combination of signing and registration of the player as the first case carefully consider the import of signing a first professional contract and ruled that it's not just the mere signing of a professional contract, but the registering of the professional that triggers the payment of training compensation. This is important and crucial when you consider the provisions of even Article 5 of the Clearing House Regulation, which provides that the automatic computation of training compensation would only happen when information regarding the registration of the player comes from the registry club to the relevant member association. So if there is no information from registration, then there cannot be a trigger for the payment of training compensation.
Okay. You spoke about burden of proof. You talked about, you raised issues with respect to tendering of travel documents, international passport. Can you throw more light again on that?
Okay. Thank you very much, esteemed arbitrator. Esteemed arbitrator, paragraph 1 of the Moot Fact explicitly states that Emperor is an magician and he joined Enugu Rangers only as an amateur. When Emperor joined Enugu Rangers, all of these requirements were not in contention at that point in time, and as such, it was possible for them to have registered him as an amateur. However, due to the strictness of administrative protocols regarding the registering of a player as a professional, as evidenced in the MPFL framework of 2023-2024, which we have extensively considered in our recent submissions for the respondent, it is clearly provided in Article 13.5 of the MPFL framework that it is upon compliance with these requirements, which these requirements are that the player must undergo a dedicated medical session, the player must submit a passport, the player must also go through other administrative protocols. All of this is in a bid to ensure that this player is duly registered.
And you are saying that the claimant did not do that?
And we are saying that Emperor was not registered.
It's okay.
Did you finish everything? No?
Yeah.
Did you finish? Okay, you want to ask me?
Yeah.
Okay.
Yeah, I'd just like to ask the claimant. I'd like to ask the claimant, please. You talked about the fact that you believe that you're owed some training compensation based on first registration, but there was no figures mentioned. You didn't talk about the category of the club of the Enugu Rangers. Do you know how much you're actually due?
Thank you. Thank you very much.
Madam Arbitrator, by virtue of Article 5 of Annex 4, it provides for calculation of training compensation, and it says that training compensation will be payable with a number of years that the player has trained with the former club, and the new club is expected to take into consideration the cost as though they had trained the players on their own, and this is a way in which training compensation can be calculated. For the category of the club, Enugu Rangers is stated as a professional club, and as such, it is a Category 2 club, and our clients in this instant case are entitled to training compensation from them. Thank you very much.
Calculation. If you're putting a claim in, you need to say how much you're expecting.
Thank you very much. By virtue of Annex 4, Article 4 of Annex 4, training costs will be determined by the club. Training costs will be determined by the amount that the new club would have paid as though they had trained the player on their own.
Okay, we'll leave it there. All right, thank you very much.
Thank you very much.
Before me, I have one question. Did you vote the Nigerian Federation as a respondent in this case? Did you vote a Nigerian Federation as a respondent in this case?
Not at all, Mr.
Not
Bishop.
at all. Okay, so I want to ask you a question also. This is the claimant, and this is the claimant for Post Club, right? Post Club, Ahram, and I think Inter Cairo, something like that. I see in your claim that you put the Nigerian Federation as a second respondent. So, did it mean that you submit a counter claim, or this is another claim?
Okay, thank you very much for that question. According to the rules of this competition, I think Rule 4.4 states that to make our own claim, we didn't know what they're coming with until yesterday.
You won't submit a new claim?
Sorry?
You won't submit a new claim or a counter claim?
Okay.
But put in your consideration, there is no a national federation as a respondent, as a claimant.
Yes.
So, this is a new claim or a counter claim?
Mr. Lutito, yes, as I was saying, the rules of this competition have not told us that we should just come and reply to them. So we prepared this without any information of what they were coming with. So when we said that they were going to bring the NFF, because Article 17.4 of the Clearing House was actually create a position where the NFF could actually be responsible to pay this training compensation. So we prepared ahead and are stating that the NFF is under no obligation to pay this training compensation.
I got, but I want to ask another question. Is it working? Yeah, great. In your minute number 3, there is like accusation to the claimant that he didn't take this, or he disregarded the laws and regard minors. Is that a counterclaim?
Mr. Lutito, that was to demonstrate that they did not have clean hands. We already demonstrated full
The bad
function.
faith.
Sorry?
I want to demonstrate the bad faith.
Yeah, exactly, Mr. Lutito. There was no transparency on the hands, so
But you didn't
everything
ask-
cannot come to
You
their
didn't
aid.
ask for it in the requests, like for the reliefs.
Is our third relief. We urge this panel to find that the claimants have dealt with the player in a way that disregards FIFA's laws and regards minors. That's our third relief.
Thank you.
Thank you very much.
Okay. You will take other question to after that?
Yes.
Or finish everything now?
Yeah, after.
After that. Okay, so now we'll start with the claimant. First of all, you have to introduce yourself and you have to be strict with the time limit. The claimant, you. Okay? Okay, you need the mic. You will start here. Okay. So you have to introduce yourself first. Okay. So
Good day, esteemed arbitrators and members of the panel. My name is Ajibola Oluwadamilola, and appearing alongside with me is Dara Ogunowo. Our humble appearance is for the claimant in this case. Ajibola Damilola and
Good day, panel of arbitrators. My name is David Iyazo, and with me is my colleague.
David
Iyazo. and with me is my colleague Idesuke Ayeni, and we announce our appearance for the respondents. Enugu Rangers FC.
Okay, now we will start. We will start with the claimant. You can start the argumentation, and we need you to be straight with the time limit. Okay.
Thank you very much, sir. Before we move into our substantive argument, the claimant would like to state their submissions before this Honorable Chamber for Dispute Resolution. And we have stated out 3 submissions. Number 1, that this panel recognizes that both the first and second claimant, which is Alaram FC and Intercareer FC, are entitled to training compensation from the respondent, Enugu Rangers FC. Secondly, that this panel should reprimand or sanction the respondent in this case for violation of crucial TMS and FIFA regulations. And lastly, that the training compensation calculated in merit 3 of the claimant's memorial is accurate and should therefore be upheld by these honorable chambers. We also pray that any other relief or remedy that this honorable chamber deems just in favor of the claimant should be granted. Now, for our substantive argument, I would like to defer proceedings to my colleague here to take them. You'll be taking merit 1 while I take merit 2 and 3.
Profound greetings to this honorable chamber. I am Dara Gunawo, and I seek the leave of this honorable chamber to go on with our preliminary issues first before we proceed to our substantive argument. Mr. Chairman, the issue of jurisdiction is the bedrock of any proper court or panel in every legal system. And that's why we've addressed that emphatically in our brief of argument, just in case any issue concerning jurisdiction rises along the line. Mr. Chairman, without proper jurisdiction, it's like complaining to the wrong authorities or persons, which not only delays justice, but also the proper proceedings that should have started at appropriate corners. Mr. Chairman, the jurisdiction of the DRC in this case has been well and clearly established in Article 22, Sub 1D of the FIFA RSTP. In a similar DRC case between IF Sylvia vs. Bombay, whereby the dispute of training compensation was brought before the DRC, the decision was given in favor of the claimant. However, this is just one of numerous cases that has cemented the jurisdiction of the DRC over a case like this. It is on this note that the claimant affirms that the dispute resolution chamber is the rightful place and has the jurisdiction to preside over this case. Also, Mr. Chairman, as it is established in the common legal maxim, affirmative non leganti incombi probatio, this means that the burden of proof lies on he who affirms, and he who affirms must prove. This in essence means that the burden to prove that both claimants are entitled to training compensation lies with the claimants themselves. This basic legal principle does not go without legal and judicial backings. In the case of Sports Club International versus Alas Verona Football Club, it was held by the panel that the burden of proof to establish that a player completed his training period before his 21st birthday lies with the club that claims it. It is therefore the humble submission of the claimants that the burden of proof to prove that both claimants are entitled to training compensation lies with the claimants themselves. And it is on this note that we'll be proceeding to the first merit of our substantive argument that is concerned with the entitlement to training compensation. Mr. Chairman, the main issue being argued by the claimant is that of training compensation, which is a mechanism designed to promote and incentivize investment in young football talent, which is evident in the case of Emperor. Mr. Chairman, the Court of Arbitration for Sports has consistently emphasized the essence of training compensation in its various decisions. This importance was explicitly recognized in Tuzla's 4AS versus FIFA, citation duly stated in our brief, that training compensation serves as a crucial mechanism to protect clubs that invest in the training of young players. The panel also reiterated, and I will seek the permission of this honourable chamber to read exactly as the panel reiterated. The panel reiterated that the compensation system is not merely a financial transaction, but a systemic intervention designed to preserve the integrity of football's developmental infrastructure. Mr. Chairman, training compensation therefore plays a crucial role in the advancement of young players, thereby ensuring the stability and integrity of the sport, as noted in Valletta FC versus Apollon Limassol. It is important to note that this principle was also noted in Club Atletico versus Football Association citations duly stated in our brief. The panel, in this case, did not at any point negate or contradict any argument put forward by the appellant, where they stated that the mechanism aims to encourage the recruitment and training of young players and discourage the poaching of young talents by wealthy clubs. It is straight and clear what stated in Article 20 of the RSCP. Article 20 of the RSCP states that training compensation shall be paid to a player's training club when the player first registers as a professional, and each time a player is transferred until the end of the calendar year of his 23rd birthday. It is well established in the jurisprudence of the FIFA DRC and reiterated in a decision in 2019 that if two clubs conclude a transfer agreement providing for the respective financial obligations, that is a transfer fee, training compensation is considered as being included in the transfer fee. However, if the parties wish to stipulate the contrary to their formation, that is training compensation being due in addition to the transfer fee, the clubs need to explicitly mention it in their transfer agreement. Distinguished arbitrators, the only exceptions for a club where they would not be able to claim training compensation, according to Article 2.2, is if the former club terminates the player's contract without just cause. 1, 2, if the player is transferred to a Category 4 club. 3, if the professional reacquires amateur status upon being transferred. Mr. Chairman, assuming without conceding that there were really exceptions, you would agree with me that this current case does not fall under any of these exceptions, hereby guaranteeing the claimant to training compensation. Distinguished arbitrators, as stated in paragraph 1 of the Moot Fact, Al Aram FC's contribution from 2017 to 2020 in Emperor's training years from ages 12 to 15 years shows their entitlement to training compensation according to statutory provisions. The club's achievement of affiliation with the EFA aligns with the FIFA principle for training compensation. The claimant further submits that Intercaro's subsequent training contribution from January 2021 to June 2023 continued Emperor's footballing education and has already entitled Intercairo to training compensation. Distinguished arbitrators, in Case 2004/8/560, the panel confirmed the decision of the FIFA Dispute Resolution Chamber, according to which a club that trained a player as an amateur for a certain period of time before concluding an employment contract with him shall be compensated for the entire time he trained the player, and not only for the time he trained him as a professional. Also, the professional contract between Emperor and Enugu Rangers Football Club on January 1, 2024 serves as the precise trigger that entitles the claimant to training compensation. In Case 2003/0/527, the tribunal firmly established that training compensation becomes due upon the signing of the first professional contract of the player, and this is irrespective of administrative complexities in the TMS which Enugu Rangers FC is guilty of. Mr. Arbitrator, flowing from our above arguments, we contend that both claimants are entitled to training compensation, and we pray that this honourable chamber holds the same in favour of the claimants. Thank you.
Profound greetings to Mr. To the arbitrators, I'll be taking merit 2, which talks about the violation of TMS and FIFA regulations by the respondent. The definition of the transfer matching system has been well defined in the FIFA recipe 2024 edition as a web-based data information system with the sole purpose of simplifying the process of international transfers as well as the transparency and the free flow of information. It is important to note that TMS stands as a foundation in ensuring the integrity of the international transfer system, and it also serves as a means in the exchange of accurate information between clubs and proper authorities in the international transfer sphere. The main objective, therefore, of the transfer matching system is to ensure that every relevant and important information on international transfers of players are submitted and uploaded to proper authorities. Now, compliance with TMS regulations has been well upheld and consistently by the Court of Arbitration for Sports, specifically in the case of Hellas Verona FC versus Latvian Football Federation versus JFC Skonto, where the Court of Arbitration for Sports affirmed that the TMS is not just an administrative process, but also a fundamental process in ensuring the transparency of the entire system. As stated in paragraph 3 of the statement of the Moot fact, the respondent, Enugu Rangers, offered Emperor, the player in question, his first professional contract on the 1st of January 2024. 6 months after Emperor signed this professional contract with the respondent, such information was not uploaded into the TMS of the club, and neither was the player status updated. Now, Article 5.1 to Article 5.3 of the FIFA Clearinghouse Rules clearly states the compulsory and mandatory need of uploading and updating a player status at the time of such contract. Article 5.1 provides that the first registration of a player as a professional at the same member association where he was most recently registered as an amateur shall be entered or confirmed by the member associations in the electronic player registration system following a request, emphasis on following a request from the club for which the player will be registered. Now, applying this statutory provision to this present scenario, the respondent is obviously the most recent club where Emperor was registered as an amateur before he signed his first professional contract. So therefore, the onus of updating or requesting to update his player status into the registration system clearly lies on the respondent. Article 5.2 also provides that the electronic player registration system shall communicate the details of the first registration of a professional to FIFA through the FIFA Connect interface within 30 days after the domestic registration. Therefore, the defendant, following the defendant's failure to upload or to request the update of crucial developments, which is his player status from amateur to professional, has not only hindered the objective of the TMS in the first place, but has prevented a proper authority, FIFA, from such crucial information. As said in the legal magazine stated in our brief of argument, which translates to law is the perfection of reason, which commands what is useful and necessary and forbids the contrary. The substantive and procedural laws with their compliance has been consistently held by the Court of Arbitration for Sports. Based on the evidence presented, it is clear that the respondent, Enugu Rangers FC, has intentionally disregarded these laws. In conclusion, the claimant submits that the failure to request or to update the status of Emperor, even after 6 months where he has signed his professional contract, even if not intentional, is not an excuse, and the respondent should be reprimanded. And this has the or sanction for this has also been supported by Article 16 Annex 3 of the RSTP. Now, moving on to our last issue, which talks about the training compensation that is due to both clubs. Mr. Chairman and fellow arbitrators, it is clear from the argument put forward by the claimant that both claimants, FLAM FC and Inter-Cairo FC, are entitled to training compensation from the respondent. Therefore, according to the rules governing training compensation, the claimant humbly submits what is due for both clubs. Now, for the calculation of training compensation, it has been clearly specified in Article 4, Annex 4, rather, of the FIFA RSTP. Now, you might be wondering why this was specifically stated and not arbitrarily controlled by FIFA. This provision has been provided so that training compensation fees for young players who are gold mines, who are regarded as gold mines in their young age, are not at outrageous or ridiculous prices to the buying clubs. I'll be referring to Article 4 and 5 of Annex 4, which provides specifically how training compensation fees should be calculated. Article 5.1 provides that as a general rule, to calculate the training compensation due to a player's former clubs, it is necessary to take the cost that would have been incurred as if it was the buying club that trained the player itself. Article 5.2 further states that accordingly, the first time a player is registered as a professional, the training compensation payable is calculated by taking the training costs of the new club multiplied by the training number of years of training in principle from the calendar year of the player's 12th birthday to the calendar year of his 23rd birthday. In the case of subsequent transfers, training compensation is calculated based on the training cost of the new club multiplied by the number of years of training. And lastly, Article 5.3 provides that to ensure that this training compensation for very young players are not set at unreasonably high levels, the training cost for players from their calendar year of 12-year-old to 15 years old will be calculated as that of a Category 4 club. Now, it was clearly stated in paragraph 2 of the Moot Fact that Emperor, the player in question, joined the second claimant, Inter-Cairo, from January 1, 2021 until June 30th, 2023, spanning a time frame of 3 years and some months. Now, flowing from the paragraph above, it is glaring that Article 5.3 of Annex 4 does not apply to Inter-Cairo FC, because as at the time Emperor joined them, he was above 15 years old. Now, applying Article 5.1 and 5.2 of this annex, Enugu Rangers FC, the respondent, is a Category 2 club under CAF. Therefore, calculating it as if they trade Emperor will amount to $30,000, which is uploaded in the FIFA circular, as the case may be, multiplied by the 3 calendar years under which Emperor trained with them. When this is multiplied, this amounts to a total sum of $90,000, which is due to the second claimant. Now, moving on to the first claimant, which is FLAM FC. Before the calculation is made, I would like to know some intricate details before this honorable panel. Emperor joined FLAM FC in 2016 when he was 11 years old, and he left the club in 2020 when he was 16 years old. Article 5.3 of Annex 4 therefore applies to FLAM FC due to Emperor's age as at the time he trained with them. Furthermore, applying the provision of Article 5.3, it is clear that it applies to FLAM's training compensation fees, because the year 2016 will not be counted, as at that time Emperor was 11 years old, and it is stated that training compensation is only calculated from a player's 12th year. Now, before the calculation of the fees, we would like to bring to notice before this honorable panel the equitable code, which states that equity does not come to destroy the law, but to fulfill it, and in special cases to mitigate the harshness of the law at times. The claimant is well abreast of the law, which states that only clubs who are affiliated with a football association is entitled to claim training compensation, and this is clear in the case of Al-Aram FC, because for about 3 years, or the first 2 years, they were not affiliated with the Egyptian FA. However, I would like this panel to note the essence, the main essence of the training compensation, which is that to compensate these clubs, which has contributed immensely to young players.
Just take a minute to...
Thank you very much, sir. It would therefore be discouraging and disheartening to see that those training years go to waste without at least compensation, when it was clear that Al-Aram FC did not have the financial and structural resources to have affiliated with an FA at the time being. It will also be bad on them because training compensation for the 12 to 15 year is calculated,
go to your prayer,
which is relatively cheap. Respondent has calculated Inter Cairo being entitled to $US and entitled to $6,000 if the first 3 years are counted, and if not, $2,000. That'll be all.
So Claimant, we need to know your request at the end.
That's our request.
Yes, tell you.
Compensation. The respondents should be reprimanded for their violation of TMS and FIFA regulations.
Okay.
And the training compensation can be accurate with FIFA statutes.
To the respondent.
Greetings once again, panel of arbitrators. I remain David Ihazo, representing the respondent. And please, before I move forward, I want to plead with this. Draw my attention to in any way when you are not hearing me, because I'm a little bit under the weather. Thank you very much. So I will be handling merit one of our issues in 7 minutes, and my colleague here, Idesuke Ayeni, will be handling 8 minutes, and we reserve 5 minutes for our reporter. So I proceed with merit one of our issue. That is, whether or not Al-Aram FC deserves training compensation for Emperor in light of John with the Egyptian Football Association in 2019, 3 years after he had joined the club as an amateur in 2016. We defendants assert that Al-Aram is not entitled to any training compensation because it was not a club and was not affiliated with any association. FIFA statute in its definition 14 defines a club as a member of an association that is a member association of FIFA or a member of a league recognized disposition that at the time of Emperor's training with Al-Aram FC, it was not affiliated and hence had entered no competition. FIFA started through its provisions, particularly the provision of Article 20, that clubs are to operate under the umbrella of a member association to be recognized under FIFA's regulatory frameworks. Thus, from the time of training in 2016 until later in 2019, Al-Aram was not recognized by FIFA and the regulatory frameworks were henceforth not binding. Article 1, sub 2 of the RSTP, which guides the transfer and regulation of players within and among FIFA member associations, notes the rules. Al-Aram has failed to meet any of the stated standards in the above provision as a club at the time of training Emperor. Thus, for a club to claim training compensation, it must be affiliated with its. This disposition was seen in the case of Valenciennes FC and Raja Casablanca, with citations duly provided in our brief of memorial. The CAS, where it was rule by the CAS that only affiliated clubs operating within the formal governance structure of national associations are eligible to claim training compensation. This was also the case of Atletico Santos FC, citation duly provided. Following these precedents, trainings conducted before 2019 was not subject to regulatory oversight. This disposition is supported in the provision of Article 4, Paragraph 7 of FIFA Clearinghouse Regulations, which provides that subject to Article 17 of these regulations, only players registered by a member association within a club and identified with FIFA ID through the electronic system described in this article shall be considered for the automatic calculation and payment of training rewards. The position of Al-Arham FC henceforth is that the legal framework of FIFA bears the general legal principle extopic causa non oritur action, which means from a dishonorable cause and action does not arise. Thus, the principles in FIFA statutes and other regulatory provisions ensures that training compensation is only awarded to clubs that operate within FIFA's regulated framework, preserving the integrity and transparency of the system, allowing the claimant to incentivize regulated training practices outside FIFA's governance, undermining the objective of training compensation mechanism. It is for this reason that we, the respondents, Enugu Rangers, respectfully request the following reliefs. First of all, a declaration that Al-Arham FC is ineligible for training compensation, and it was not affiliated with the FIFA, pardon me. And secondly, a dismissal of Al-Arham FC's claim entirely, and an order that any cost associated with this proceeding be borne by Al-Arham FC entirely. I now hand over proceedings to my co-counsel to handle the second issue.
Thank you very much. I pray this honorable court to continue proceedings from my colleague. Once more, my name is Idris Kaini, and I am representing the respondent, Enugu Rangers, and I'll be arguing on merit 2. Whether or not Enugu Rangers is obligated to upload the players' data on the FIFA transfer matching system, and whether it's liable for any compensation to Al-Haram and Inter Cairo. However, before I move further, I would like to give an overview of the legal frameworks that guide this. First, I will define who professionals and amateurs are in football. This is provided in Article 2, Paragraph 2 of RSCP, which defines, if you permit me to read verbatim, a professional is a player who has a written contract with a club and is paid more for his footballing activity than the expenses it effectively incurs. All other players are considered to be amateurs. Further, the concept of training compensation is provided in Article 20 and also Annex 4 of the RSTP respectively. Now, further, Annex 4 Article 2 provides that transfer compensation is due when a player is registered for the first time as a professional, or as a professional is transferred between clubs of two different associations. Now, based on paragraph 3 of the same provision, FIFA Clearinghouse guides that this legal determination of the facts provided accepting its legitimacy and application on parties. Now, it should be noted that there are two coexisting regimes, international and national, and the RSTP provides for this and respects it. Now, what are these regimes? For international transfers and registration, it is being guided by the TMS and the RSTP. And for national, it is being provided by the electronic registration and transfer system, and also provisions of the RSTP, which also accepts rules and regulations by the association. Now, according to Annex 3, Article 1, Paragraph 2A, it states, TMS has a specific objective to monitor and regulate the procedure for international transfers of players. Now, further, Annex 3, Article 2, Article 2, Paragraph 2 of the RSTP provides, it is mandatory for associations and clubs to use the transfer matching system to transfer professionals and amateur players internationally in 11 aside. I want you to take notice that TMS regulatory framework for international transfers and registration. You might ask, where am I going with this? Let's continue. Now, also, Article 1, Paragraph 2 of the RSTP provides that national transfers and registration issues are to be governed by specific regulations issued by the association concerned. This is as per Article 1, Paragraph 3 of this same regulation. Now, it is established fact that the transfer from Inter Cairo to Enugu Rangers was an amateur one, and it followed the regulation of the transfer matching system, which Enugu Rangers complied with. Going further, Article 5, Paragraph 1 of the RSTP provides that each association must have an electronic player registration system, which must assign each player a FIFA ID when a player is first registered. Now, because of the limitation of time, I will give the total definition of this electronic registration system. However, I will itemize some of the characteristics. One is that it's an unlike electronic information system. It registers players as an association, and then it is connected to various FIFA interfaces, including the FIFA ID. Now, Enugu Rangers have no legal obligation to based on the facts of this case. Rather, it is to be done in the electronic player registration system as required, which the respondent asserts to have complied with. Now, you might ask, what is the process? Now, those to further establish our position, Article 5, Paragraph 1 of the FIFA Clearinghouse Rules, it states, the first registration of a player as a professional at the same member association where the player was most recently registered as an amateur, entered or confirmed by the member association in the electronic player registration system following a request from the club for which the player will be registered. Now, Sub A of this same regulation states, if the first registration as a professional is with the same club where the player was most recently registered as an amateur, the member association should the status of the player. These regulations apply to the facts of these images. Now, it should be noted that it is established, notice should be taken that the registration is to be done by the association upon the request by Enugu Rangers. We complied. We unequivocally state that we complied by sending a request for the registration of MPL. Now, it is established through various provisions, including Article 4, Paragraph 4 of the FCHR, that each member association shall maintain and update the player registration data in its electronic player registration system and FIFA Connect ID Services Act. Further, the responsibility of the update of the status of the player does not rest on the club, however, rests on the member association. Now, the first registration as a professional shall be entered or confirmed by a member association in an electronic registration system following a request which I've already reiterated before. Now, any failure, we want to establish that any failure rests on NFF or the Egyptian Football Association and not Enugu Rangers. Notice, we are entering our defense for the respondent, Enugu Rangers. That should be taken notice of. Now, the respondent assumes, but not asserts, that NFF must have updated the player status and communicated to FIFA. We can't assert. Why? Because this is not under our obligation, but rather NFF. And this is being provided in Article 5, Paragraph 4 to 8 of the FACA. Sorry. Pardon.
Get you, go ahead.
Good. Generation. Now, it should be noted that in case where training compensation is needed. An EPP must be generated. There was no when the EPP of MPERO, when generated, had no reference at no time to Al Arhan FC or Inter Cairo. Now, further, Article 8, paragraph 3 sub B of the FIFA Clearinghouse Rule states, a club not listed in the provisional EPP and that it should be included may request its association to be included. Well, I would say that Al Haram and Inter Cairo didn't do that. Not our obligation, their failure. We also assume that no trigger was identified by the TLS because according to Article 5, paragraph 3 of this same provision, it provides that the TMS will identify any entitlement and communicate this in accordance with the provision of the RSTP. At no point was it communicated to we Enugu Rangers, saying that there was no trigger. Not still our obligation. Going further, consequently, no trigger was identified. Now, Enugu Ranger asserts that if there is a failure to update the status of the player denied, the NRM and Inter Cairo from training compensation, it is not Enugu Rangers' liability. However, liability lies on the member association for this failure. This could be either NFF or the Egyptian Football Association, and this is according to the provisions in Article 17, paragraph 3 of the FIFA Clearinghouse Rules of the Egyptian Football Association, or according to Article 17, paragraph 4 of the FIFA Clearinghouse Regulation, which provides that the liability lies on the member association when it fails to communicate the registration. That is on the part of NFF, and also the member association will be liable on the part of the Egyptian Football Association when it fails to communicate the trigger of a training compensation. Therefore, we submit our prayers, which we have given in our brief, that there be a declaration that Enugu Rangers has no liability, that there is a dismissal of all claims by Al Haram FC and Inter Cairo, and that there should be a restitution and sanction against NFF or the Egyptian Football Association, if necessary, that they found to have been liable in negligence according to Article 17 sub 3 and also Article 17 sub 4, and not Enugu Rangers. And that the cost and other expenses borne by Al Haram FC and Inter Cairo, that the cost and expenses should be borne by Al Haram FC and Inter Cairo, as their claims hold no water. Thank you. These are my submissions. Thank you.
Thank you for your recommendation. So we move the floor to the claimant. I think you have 5 minutes to answer every. Yes, sir. Mr. Muhammad will ask you a question.
What jurisdiction are you admitting your submission to?
Jurisdiction, CAS.
You did CAS?
Yes.
You did that for CAS? You did that for CAS?
Yes, sir.
Did you solve their claims?
Yes.
Did you solve it?
I didn't get that. This claim consistently.
You didn't solve the claim?
Show the claim.
The claim itself.
I think they don't show.
Yeah,
you don't show the
exchange your
No, we exchanged our briefs.
Yes, yes.
We did.
Yes,
we did exchange our briefs.
You studied very well?
Yes.
Okay.
No, permit me to.
Yes.
This was.
Go ahead.
This was during limited time. It was limited time, less than 24 hours. We used to study their brief.
24 hours?
Yes. Less than. Thank you very much.
So we'll move the floor to the claimant to answer to all questions and
Honorable panel, before
there is
this,
a question, if you have 5 minutes or more. Okay?
we just have 4 main issues that we want to report based on the brief we received from the respondent. The first one is that the merit 1 of the respondent's brief, they talked about that Alaram FC, which is the first claimant, is not entitled to training compensation because they were not affiliated with a football association, which is the Egyptian Football Association. However, I would like to bring to notice, also in paragraph 1 of the facts of this case, which stated that in 2019, Alaram FC became affiliated with the Egyptian Football Association from 2019 to 2020. And within that period that they got affiliated, Emperor was still training with them, which means that even if those 3 years are not counted, for the 1 year in which they got affiliated, they are still entitled to training compensation. Now, the second issue which I would like to bring forward is that it is clear from the facts of this case that there are 2 claimants, which is Alaram FC and Inter Cairo FC. However, when they addressed the issue of training compensation, they only mentioned Alaram FC. They did not in any way make any regards as to Inter Cairo FC, and I would like to assume that their silence about Inter Cairo's entitlement to training compensation is that they are conceding that Inter Cairo FC is entitled to training compensation, because it was clearly stated in the facts of the case and also in our brief. Now, the third issue which we would like to iron out is that the deliberate attempt from the respondent to mislead this honorable chamber by misquoting the clear provisions, specifically Article 2 of Annex 4, which was stated in paragraph 1.8 of their brief. What they stated in that paragraph was not in any way in resemblance with what was actually stated in such FIFA statutes of the RSTP. Now, to our last issue, the respondent has also, it is clear that the respondent has also imported facts into their memorial, which should not just be deemed as just a mistake, but a deliberate attempt to mislead this honorable chamber again. And I'd like to refer this honorable chamber to paragraph 2.11 in merit 2 of the respondent's memorial, which is clearly alien to us and is not in any way contained in the moot facts of this case. That will be all for our rebuttals.
You finished all sense?
Yes.
All argumentation? Okay. So now we move the floor to the respondent again. And you have the same time?
Thank you very much.
Okay.
We would like to reinstate our position that the claimant has wrongly applied the provisions of the RSTP. They argue from the point of view of TMS, the Transfer Matching System, and the International Transfer Legal Framework and Regime, not taking into cognizance the provisions for national regulation, which is being provided in the RSTP. Meanwhile, it should be noted that in Article 1, sub 3, it gives exceptions to regulations that the National Association could actually make difference to. It never mentioned for Article 20, which provides for training compensation. Further, we would like to also identify that the claimant feigns ignorance about our response to Inter Cairo, as we have addressed this in the very 2 of our issue. This will be all for now. We'll take questions from the arbitrators. Thank you.
You finish everything?
Yes.
Arbitrators has any questions?
Well, we've come to the end, I think.
Yes.
I think before other points I have to make, I have to say that we are so elated, we are so proud of these teams. We are excited about the future. Abuja, Unilag, Unilorin, AAU, fantastic, just incredible how you are able to come to this level of advocacy. We are shocked here And I tell you, in the morning we said, it's not about the scores, really. It's not. But it's about the substance, and you've shown today that you've got great substance. All of you, all of you. Yeah, just to add or point out, most of the arbitrators here kept asking to find the issue of jurisdiction. It must be clear in your pleadings. Anytime, any day, must be established that this is competent to hear this matter. That's why we asked, is it CAS? Is it DRC? Is it the High Court of FCT? So, and be mindful of your dates. I'm not sure any of them signed properly. I'm not sure any remember the dates. There is a structure for submissions before the bodies. But beyond that, these things are things that can be corrected, but beyond that, I know it's not just the arbitrators. I know people, the audience, are thrilled by what you've been able to dish out today, by your passion, by the force in your tones, by also the humility in your submissions. And I will just say, keep it up like this, and we wish you the best.
Yeah, I just wanted to add to that. I just wanted to say, probably as a female, sports lawyer, I just wanted to say it was beautiful to see you here, young lady. Here in the final, you're the only female who made it through to the final, and it just goes to show football is not just for the boys, and neither is sports law. So keep that up. Like Barrister Moot mentioned, there's certain structure when you're submitting claims to make it easier for those who are reading through. I mean, the briefs, I've really enjoyed reading some of the briefs. Some of them could be structured a little bit better, but the level you guys are at for university students is absolutely amazing. Again, going to University of Ilorin, always make sure that if you're putting a claim forward, you need to say how much, this is how much I'm expecting to get. You saw that the other claimants had a figure. Whether the figure was, correctly calculated is a different story. We can look into that later, but at least you put something forward, and then that's something that the respondent can answer to. And then another thing as well is, I don't think any of you mentioned the fact that because of the dates, we mentioned dates here, when the transfer actually took place, we're now using the FIFA clearinghouse regulations. So I don't know whether anybody picked up on that, because it took place in 2023. And the FIFA clearinghouse regulations came into play in November 2022. Right, okay. So really, the DRC wouldn't have been the governing regulation if not for the fact that it didn't go through the TMS EPP process. So I know that you guys mentioned something about the fact that if the club wanted to, if they didn't go through the EPP review process, they could, put a claim in, and that's why it kind of defaults back to the DRC. Otherwise, it would have been, the FIFA clearinghouse. It would have been under the FIFA clearinghouse regulation, and that's also in the RSTP if you read through that. Yeah. So, but I just wanted to say well done to you guys. Amazing, amazing, and the passion, and the kind of knowledge, the technical knowledge you guys have. I don't know how much reading you did, because. Some of the stuff you were covering, I was like, wow, can you just check that, make sure it's accurate? So yeah, well done, very well done.
Thank you, Mr. Bey, for this information. Mr. Mohammed, do you have a question? You don't have a question? Okay, Michelle, do you have any question?
Actually, I feel interested by this amazing Moot court. And actually, other than what the arbitrator say, I really proud of you because you're so young and you act like professional lawyers in a real court. I'm also proud that there is a female sports lawyer. My only comment on your pleading is pleading is like an acting. So you should take care of your tone while you're pleading. So you don't have to be like speak loudly all the time because maybe it's annoying, and also you don't have to be like quiet because that may be boring. Your attitude or your performance in the pleading or on the hearing, it's like you convince the arbitrator by what you say. So you should know when I should raise my voice and when I be quiet. That's it. So thank you for your pleadings and for your time and your effort.
Thank you, Ms. Sharma, for your information. For me, really, as my colleague said that I'm proud of all of you. Really, you did well. All of you made a good effort. But as Mr. Amobi said, that we just gave you notice. We are here to give you some notice to make you take care about these minor issues when you graduate and practical law. For me, as a lawyer and a fighter in the court, I like to be focused in the procedure, in the jurisdiction. For me, I like it. Sometimes I'm not going to the merits, but I stop and win the case in the jurisdiction. This is very important. The formal matters. To be honest, you did very well, but all of you, your claims is dismissed for the procedural matter, for the procedural aspect. All of you I think, get an interest and an attention to the merits more than anything for the procedure. Article 18, I think, and I'm sure, no one saw to Article 18 from FIFA procedural rule for corporate tribunal. I'm sure of that. So this is very important point you have to take care about. I think you all have a common stakes and a common error. Maybe you can take care about it in the future, in the next. You didn't mention to the name of the court. Some team said that this is a CAS, DRC. So what is this court? Which court we are? It's a CAS or DRC? DRC. It's very important to take care about the jurisdiction, because if you go to the CAS and the case is before football tribunal in DRC, I will win the case without doing any effort. The respondent to the case, because you go to the wrong court without going to the merits. Just one paper, I will win the case. Also, I think the date, as my colleague said, you didn't mention the date, you didn't write the date. Signature. You didn't write signature. You didn't put your signature. This is the main requirement for the Article 18 to admissible the case before CAS, before football tribunal. Some of you, some teams, I think, said that this is an agent. You are agent or lawyers? You are agent or lawyers? This is a key question. Okay? Yes. So I think also some teams also put the National Federation as a respondent without any claim from the claimant. Because when you want to put another party, you have to submit a new claim, or you have to answer to the claim of the claimant only. You can't enter another party outside of the request of the claimant. You know, other than the claimant, or the claimant's, I think, 2 clubs. So you can't, when you answer, you can't put another party without telling me this is also some of you are, I think, also 2 teams requested a sanction, right? I think you request sanction and you request sanction, right? But you didn't establish this sanction in which any article. So it's very important to know that. All of you, except this team, calculated the training compensation. I think respondent not required to calculate it, but this is only teams that calculated the training compensation. You didn't vote for me the applicable law. So do you use FIFA regulation only, or you can use series law as a competitive term? This is a very important point you have to think about. The party, all of you, I think maybe 3 teams, except 1 team, I think this team, that talking about the parties of the claim, put in the list of the matters or the list of the content, the party. So I know when I open the memorandum, I know which is party for this claim. All of you didn't mention to the nationality of the parties. It's very important to mention to the nationality. Yes, I know that Egyptian and Nigerian, but you have to write it. Okay? You didn't mention to the name of the lawyers. It's very important. Article 18. If you submit this to the FIFA will dismiss. If you submit this to the FIFA without comply with Article 18, FIFA will dismiss it. I think all of you will organize the paper. All of you, yes, use the CAS cases. But I have one note here. When you mention to the CAS case, you have the precedent case from CAS. You have to inform me which paragraph in this decision you use. Right for me. Don't tell me the CAS number, blah 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 blah. Telling that. So okay, which paragraph, which article, which sentence. You have to mention it. You have to make it easy for the arbitrator, not to make him do a lot of effort, because arbitrators have a lot of times. So can't do a lot of effort to see your claim and your exhibits. So this is a very important point also. I think it's enough. It's enough. And I don't want this comment to frustrate you. This is a very important point. For me as a lawyer, sometimes I'm focusing about procedural aspect before I'm going to the merits. Because sometimes if the procedure is wrong, is a mistake, I will not require to go to the merits. So you all make something good, but we have to learn from each other. We have to care about this minor mistakes. For me, it's not minor, to be honest, but I will say minor mistakes for the future. Okay? Okay, thank you for all of you. I think now we need you to take a break for 1 minute, and we will invite you to back, okay?
Where's bio?
Right. Moderator, don't go outside. When I got come, I'm tired. You know, can play for report. Call me, I'm going ahead now. Go ahead, my back hand on the pin. On time.
So the night food you also. I think is it? How's it like?
No, number one is mine. Charge for that one. So when we were talking, I was moving. Yeah, I can never get charged, but now I'll get him. And I thought we school around past 10, 11. That's when I can't come. Leaving that camp in the following morning again. Camp in the following morning again. See when I reach yesterday. So we need to capture the names. Their invitation when they are coming.
So are we still going to come live?
Yes, no, I think they will announce results.
Yeah, I mean before, now within this break now before they come up with the decisions.
You know, disconnect now. You can put it somewhere. Yeah, you can share somewhere.
We want to still stream the judge's decision making. No. Holy Santa Maria.
There's a place where I'm watching.
Not sure.
I would love to start by acknowledging my father, Mr. Michael Lugoku. I had to acknowledge him first because he was quite sick 2012. He had prostate surgery and he was in caretaker, and I couldn't pay for jam fee, and the last money we had was the money he could have used to buy his caretaker, and he was like, he doesn't mind if his mark gets cut off as long as I go to school. So he gave me 5,000 naira for my jam for me 2012. Thank you very much, sir. I'm very grateful, sir. I also love to thank Barrister Mobi Zako. I'm calling him specifically because my first encounter with sports law was in 2016 when he came to the University of Nigeria in Soka for a sports week. And then he had a very shiny silver Benz car as a very young lawyer, and I was like, man, this guy left school like less than 4 years and has this silver Benz, looking sharp, always donating money to us. I would love to be like him. And he told us, with sports, you can make money legally outside fraud and cybercrime. So that was the day my interest in sports law started developing. I'm a sports person, but that was my first encounter with someone who's a lawyer and who works in the sports sector. So thank you very much, Barrister Mobieza. I also love to thank Ms. ABMNK. She has put me on my toes. I won't give long details, but she has really put me on my toes. She has taught me that I could be better. She has taught me what professionalism means. She has taught me what diligence means. And she has taught me that you have to proofread every paragraph or every line, every sentence before you send it out. She has also taught me that you have to learn how to address people correctly. And above all, throughout the process of planning this event, I always ran all my ideas through her. And she always responded. She was listening to me, telling me what to do, what not to do. Even I said I was tired, she was like, you can't get tired, you've come so far. And I don't know why, but she left, she was in Nigeria 3 weeks ago, went back to the UK, and still came back to Nigeria for this event. So I'm very grateful now. To Isham Islam, he's a lawyer I don't want to go against, because he drafts the longest briefs you can ever see. He serves you with about 70 pages of respondent brief, and then you don't know where to start from. So my first real encounter with him was a case we did this year, and then when we settled amicably, I thanked God I never went against him in cars, because I don't know if I would have survived. So when I reached out and I told him my dreams and ambitions, he told me, Habibi, I won't be available, but I pleaded with him. He told me, okay, I'm going to clear my schedule and come to Nigeria. Not that he came to Nigeria, he came with a wife who is the only female software in the country. I'm grateful, sir. Then from Itwali Mohammed, it was a case I had against Smuha. And we negotiated, and that was the first lawyer I had gone against that was pro-settlement. He never wanted any form of dispute. He was like, this is what you should do, this is what you should not do. And when he discovered that his clients were not doing what he had negotiated, he told me, go to FIFA. I won't stop you. And after we got judgment, he made sure my client got paid as at when due. And then after, when I told him about the idea, he told me, brother, tell me anything you need and I'll come. And I'm grateful he left Egypt and he's here today. To my first client, the sports industry, I don't know if he's here, Mr. Eugene Eremiokale, the president and CEO of Sunset Football Club, the man that took a chance on me 2020, like these young guys here that are filing before CAS as opposed to the DRC. When he took a chance on me, I wrote to the Swedish Arbitration Tribunal and told them I want to fight training compensation, not FIFA. And they responded and said, this is not the appropriate body. Mr. Eugene was like, it's a learning curve, let's learn together. We made mistakes, we filed this claim 5 good times and it was closed. The 6th time it was open, it was served on the respondent, we celebrated, he sent us money. It was as if we got victory. So I'm very grateful to you, sir, for taking a chance on that young boy that has no experience. Then to Mr. Emmanuel Odogo, president of Dominion Hotspur Football Club, I call him the biggest export of grassroots talent in Nigeria. In 2020, I was searching through the internet for cases to file, and I came across a player office, and I called him. I told him, sir, I think I can help you do this. He was like, are you sure? And he said, like, can you do it? He doesn't know me, I don't know him. And I was like, I can do it, sir. He was like, what do you need? I told him. We did the case, we got judgment. The data was credited. I told him, I turned off my phone. I had not met him then, and he paid an amount of money to me. And my BDC friend, Alhaji Abdulhamid, told me, are you sure this money is legitimate? Are you sure it's legit? Please, can I see the proof that the money is legitimate? Then my brother, Mr. Henry Koroji, who flew all the way from London, we've known for 4 years or 5 years now. I've done a case for him at CAS, at FIFA, but we've never met face to face. But we talk at least 3 hours every day for the past 4 years. When I told him about the event, he told me, brother, my wife just gave birth to twins. I just left Nigeria 2 weeks ago, but I must come to Nigeria. And here he is from the UK. Thank you, Mr. Henry. To my amazing team members, headed by Mr. Damilari, I'm very grateful because I would say this: I'm a good team player, I'm not a good team leader. Damilare has shown me what leadership means. I have snapped at him. He's in final year in the university. So he has shown me what leadership means. I think I've learned from him, even though I don't come up to his standard in leadership. But it was a pleasure working with Damilare. I'm very grateful. So Mr. Jude Kunichi, whom I called, and I told him things were falling apart. Jude left his tour around the 15 northern states and came back to Abuja to make sure that this event held. To Mr. Chika, who is a very busy lawyer, but took out time to plan events and support me, I'm grateful. To Opampo Chijoke, Israel, Tosun, I'm very grateful. I can't acknowledge everyone here, but I want to just say that I'm really, very, very grateful. And then for the students, I'm more than happy that you guys participated. And as I said earlier, it is more than a competition. This is just like a ceremony for me. The learning curve continues because we have packages for you. We plan that every month we will give you trainings at least once a month so you can learn the practical intricacies of the industry. And looking forward to next year. I can assure you that next year we'll go bigger. It is Africa. 100 universities will be here next year, and it's going to be bigger. I think at this point, I would love to thank Yadira, who's last but not the least, for her wonderful organization and all. And then as you go back to your respective destinations, I wish every one of you a very safe and pleasant flight. And I hope and pray we'll all see you next year. Thank you very much.
Okay, thank you very much, Mr. Pius. Please, can we give him another round of applause? Okay, I was just informed that Jude Lucan magazine has an award for you. So if they are ready. Is there a representative for this? Okay, Mr. Vice.
Hello everyone. On behalf of Jude Lucan Awards 2023, we want to present the award of the Eminent Sports Advocate of the Year to Barrister P.C. Nduboku in honor of your contributions towards the growth of sports at local and international level. Call on the CEO of Jude Lucan's Award to come and present the award to him.
So sorry to keep you waiting, but we deliver the panel panel. Before you announce the results, we would love to show our certificate of participation and explain to the arbitrators. So I think once we're done with this, we can announce the results and then we'll sing the Tede on like with the parts. So I would love to call on my first client in the sports industry, Mr. Engineer Kale. Okay, to help me present the first certificate of appreciation to Mohammed Mitwali.
Guys,
Yeah, for the certificate of appreciation of this APM again, I would have loved to present it, but I'm not fit. So I'd love to call upon Mr. Emmanuel Odogo, the president of the Non-Hospital Football Club, to honor us and help us present this certificate to this APM.
Congratulations. We really appreciate your contribution. Thank you for coming.
Okay, for the next one, I wish we had the NFF here or FIFA who have presented this particular certificate. I would love to call on Mr. Henry Koroji, who was it? So for the last certificate, but not the least, I would love to follow the traditions of the Nigerian military, Nigerian armed forces. When you're presenting an award or gift to a man, the wife is the one that puts the rank or the award on him. So I would love to call on Mrs. Shima Daly to do us the honor of assisting us in presenting this certificate to Mr. Bishop.
Thank you. All right, ladies and gentlemen, we have arrived at the last lap of this event, and it is the award giving time. So there are several special awards that have been curated for the finalists today, and I would be calling on each of the judges to present the award to the winners. So first, we have the award of the best brief. Please put your hands together as I invite Mr. Mohammed Mitwali to announce the winner of the best brief.
So the best brief for today, for the big day, is University of Lagos. Oh, before you leave, come here, come again. The best brief has 100,000 lira as a prize. What's next step?
Congratulations, University of Lagos. Okay, to announce the winner for professionalism, I would like to invite Miss Ebi Emenike. Please, a round of applause for her she comes.
Hello. So to announce the Miss Ebi Emenike, that's me, announcing the winner of professionalism, and that goes to University of Ilorin. We also have 100,000 naira for you guys.
Congratulations. For the award of the best advocates, I would be calling on Mr. Amobi Ezako to announce the winner.
Thank you. So, the best advocate award goes to Precious Anike from University of Lagos. We also have 100,000 naira.
All right, thank you very much. Congratulations. Finally, it is time for us to hear the results of the just completed finals. All right, so please, who is going to announce the results to you? All right, please put your hands together for Miss Ebi, who will be announcing the results of the finals.
The arbitrator will sit, she's not going to stand.
No problem.
I'm being looked after, carried like an egg. Thank you. Okay, yeah, just to say again that, you know, we've had an amazing group of students who have done us all proud and done themselves proud, done their universities proud. So can we just have another round of applause just for, you know, everything we did today. But as it's a competition, there's got to be a winner. And we're going to have a second runner-up, sorry, a first runner-up and then a winner. So the first runner-up, we have, I'm going to try and pronounce this, Adekunle Ajasi University, AAU.
His first runner-up.
Pius can do that. Yes, Pius.
Please, I would love my dad to help me make the presentation.
Second mic for you. Need to turn it down actually.
Don't forget that.
Okay, just for those that didn't see that, the cash prize was 500,000 naira. Congratulations to AAU. Now for the winner. Drum roll. The winner of Football Law Annual Moot 2024 with a total prize of 700,000 naira. I'd love to say dollars. But no, pounds. Yeah, 700,000. It's still a lot of money in this day and age. You can go very far. Is Unilag.
Yes, sir.
Please wait, you also start with the first one.
For Timmy Lad, I have great news for you guys. The president of the Union All-Sport Football Club, Mr. Emmanuel Odogu, has informed me that he's offering both of you a full year internship with his club. You have access to trainings, with official channels, and possibly some professional jobs to do. So I think you can meet up with him and then follow up with that. Then also, I have decided to give each textbook on sports law practice in Nigeria by Dr. Emmanuel Odogu to each of these schools. So I believe the team will make it available to you guys as well. Also, Hisham Islam, I think I consider his law firm the biggest. Yeah, I consider his firm, Sports and Justice, to be the biggest in Egypt and North Africa. I might be wrong, but I think personally, from my experience, is the biggest. He has informed me that Unilag also has a 1-year internship with his law firm in Egypt. Also, Mr. Eugene Rebenkale, the CEO of Sunset Football Club, my first client, paid me the first euro I made in the industry, big one. He has informed me also that AAU will have an internship placement with his club, Sunset Football Club. And also, I'll be taking on Union as the founder of this prestigious event. I'll be offering the Union Abuja team 1-year paid internship with myself personally.
Uniloring out, and because I'm here, and the Uniloring guys, you are free at any time. Anything you want from Rangers. Anything you want from Rangers, the Uniloring. Feel free to contact me. Before I leave now, I will drop my number. If it's internship, if it's any help at all, Rangers will render that to you.
All right, ladies and gentlemen, we have finally come to the end of this remarkable event. I want to thank you all, our distinguished guests, including our speakers who also doubled as our judges and panelists. Thank you all for your time, your patience, and your active participation. Thank you very much for staying here, even though the time was extended, and patiently remained here. We thank you. Please, a round of applause for yourselves. I am Yadira Ukaigwe, and it has been my absolute honor to be your host for this occasion. I pray you have a lovely evening and do enjoy the rest of your day. Have a safe journey back home. Thank you, everyone. Please, there will be a picture session outside for those that are interested, so feel free to, connect some more and take some pictures on your way out.
Yeah, good, right? Tell us now for that they call it rural rocket. You remember what that's
Thank you, streamers. We've come to an end, and we'll be ending the streaming session. But have a great day. Bye.